Hi, and welcome to the second part of the debt smashing series. So what we're doing is we're showing you how you can turn the tables on these debt collectors. The thing is, when you're looking at debt collectors, regardless of how people actually got into debt, what they're doing is wrong. What they're doing is illegal. What they're doing is lying. So because of that, then we've got the ability to fight back. So I'm showing you how to actually fight back in the legal way. You're not doing any woo-woo or like Iron Man or any of that stuff, right? This is the Magna Carta. No, we're actually using legislation. We're actually using their rules against them, and they don't like it, but they are breaking all of their own rules. So what we're going to do is point that out to them, and then we're going to put this to bed. We're just going to quickly go over the first one. So we had what we call a subject access request, the SAR. Now, when we send a legal SAR, which we have the legal right to do, then they have a legal obligation to answer it under GDPR and DPA 2018 with full disclosure. They have to be transparent. They cannot tell lies. So what they try and do is fluff around what is true. So they will never ever say what is true. So they'll say things, well, we don't need to show you this, we don't need to show you that, we don't need to show you the deed of assignment because it has some sensitive information on it where, you'll see other people's data. Well, they can do it redacted. What the GDPR and DPA legislation point blank says is that they have to supply us with all the data they hold on us. Therefore, if they have a deed of assignment, all right, let's rename that a legally executed deed of assignment, which comes under the Law of Property Act, miscellaneous provisions 1989, how it must be signed and how it must be presented to be legally executed. It's just the same as anything that needs to be legally executed by a court order or by anything. It needs to be signed and witnessed correctly. And they do not do that. Now, we have solid evidence that they actually do not do that. They never buy the debt. They only deal in data, which is illegal. They're not allowed to buy our data. But if they did a proper buying of the debt, purchase the debt, then they would have a receipt. Okay, that is all we're talking about. We're using GDPR and DPA 2018 against them because they're breaching it, and they are actually breaching our data protection, and they're breaching the general data protection regulations. So we're not going to worry about, oh, we owe the debt, we don't owe the debt, right? You've bought the debt, you haven't bought the debt. What we're saying is, well, great. You say you bought the debt, show me the deed of assignment, the legally executed deed of assignment. That's all it is to it. So we're just going to quickly share the screen and show you the number one again, just as a refresher, and I will attach it again to this one. It was attached to the original one, the first video, the SAR. So go and have a look at it. You can download it from there, right? Yeah, but I will attach the number one and the second one onto this one as well. But let's go and have a look at the first one, just a quick overview again of it before we move on to the second one. Okay, so here again, we've got the SAR, the first one that we're done. So we've got like their address goes on the left. Okay, our address goes on the right. We've got the date that we're actually doing it. We've got a reference number. You can make that up. And there is their reference number from the debt company, not from the original bank or from the original credit card. You will have a new number, a new account number from the actual debt collection agency. And all we do is we put our note quoting your reference number is for your use only, no join that is made or intended. So we can have a look at that. We're quoting the DPA and GDPR. We're putting it to the man who acts like as the director for that company. And we're telling them that it's our rights under there. And they know that they have to actually abide legally with their legal obligations to supply transparent answers to the questions. Now, we're not doing a crazy amount of questions. We do not need to. We don't want to, right? We're going to ask them under the Law of Property Act 1989 and 1925 for the actual deed of assignment, okay? So that it has to be, it's got to demonstrate its validity. Then number two, details regarding the compliance of the deed of assignment with the legal requirements outlined in Section 1 of the Law of Property, Miscellaneous Provisions Act 1989, which says it must be signed and witnessed. So, and it has to be done correctly. They can't just have it signed and then send it off somewhere and have it witnessed by someone who does not witness the signature. That's what it actually means. Okay, and also under the section 136 of the Law of Property Act 1925. Now, we're not saying that the Law of Property Act in 1989 or 1925 says they must show us the deed. That's not what we are saying. What we are saying is, under the Data Protection Act, their 2018 GDPR, they must be transparent and show us all of our data that they hold. They don't have a choice. We say, well, I'm only going to show you this one, but I'm not going to show you that one. That is what we're actually holding them with. Okay. That, pay more attention to the rights that you have under GDPR and data protection. Okay, so I'm attaching this one. It's only got 5 questions, but the first 2 are the really important ones. And the rest of it, we're just saying, show us any data that you've had with us. And number 4 is quite important as well, because this is about being transparent. Principle 6 and 7 of the Financial Conduct Authority regulations. That means that they have to be transparent with everything that they are doing. So that means they have to show us their actual deed of assignment that they have alleged. Now, if they've said they had it, fair enough. Just show us it then. So we send them the first SAR. Now, remember, on the GDPR and DPA guidelines, we have to give them a month. So not a problem. As soon as you get the first notice, that they'll call it, they'll actually call it a notice of assignment, because they like to use that word assignment, don't they? Knowing that you maybe be fooled saying that, oh, so they deed of assignment. Oh, they've got one. They're only sending you a notice of assignment. That's literally like the same as a letter from the guy Fred down the street saying, oh, you owe me that 10 grand now, by the way, because I'm saying so that, like, you know, Jimmy from that you did owe it to, now he says you owe it to me, right? It's a notice of assignment. It's literally just a letter from the debt collecting agency saying, oh, you owe me it now. Not a problem. Don't argue with them. We're not arguing the debt. We're not arguing the law. We're not arguing the jurisdiction. We are simply stating the facts that we have a legal right under the GDPR to send an SAR, subject access request. We being the subject, and we are requesting access to our data that they hold on us, including the legally executed deed of assignment. So if they've said that they've purchased the debt, they must have one. We've got the evidence backing it up here that they do not buy the debt and do not have a legally executed deed of assignment. And we're going to show you multiple bits of evidence as we go through this series. We got to send off the first one, and we have to give them a month to actually answer that and come back with whatever questions. They always come back with rubbish. I've seen them literally piles of paper that they've sent to people, and they never ever say, oh, and here's the deed of assignment, because they haven't got it. So what they'll say is like, oh, there's no law that says that we have to give you that, blah, blah, blah. General data protection regulations and DPA are very specific. They have to show us all of our data. All right, that is our data. They have no excuse. They're going to try and wiggle out of it, and they're going to say things that try, you know, that there isn't a law under the Law of Property Act. There isn't, but it comes under GDPR and DPA 2018 that says that they must be transparent, and they must give us all of our data that they held, that they hold. Okay, that's it. So we're not relying on what they have to have a legally executed deed of assignment through the Law of Property Miscellaneous Provisions Act 1989. They have to have that, but they haven't got it. So we're actually requesting to see all of our data, and that doesn't include the deed of assignment. So they've got to show us it. This is their Achilles heel. Because they've alleged they've purchased the debt, they're alleging that they have that deed. So why not use it against them by using GDPR and DPA? This is where you can hold them to account. So after that month, no matter what they've come back with, some of them actually just ignore it. They don't answer at all, right? Some of them are going to come back and say, oh, well, you know, we need to get your name and address. You can give them your name and address. You've already done it on the notice, haven't you? The SAR. So don't let them fob you off. It's only delaying tactics. If they come back and say, we're not giving you the deed of assignment because there's no law set, don't worry about it. Don't panic. Follow on the process. We are using GDPR regulations, DPA 2018. We don't care, right, that they're actually worried about giving you the deed. We're just going to follow through and create an evidence line, a paper trail, so that we can actually present this evidence at the end of it with an N1 to the court. They have breached our data. So after the month, if it's been a nonsense reply, you're going to send the second SAR as soon as you get that nonsense reply. Or if there's no reply after 30 days, then you're going to send the second one. So I'm going to go over the second one. It is a repeat apart from the ICO, the Information Commission Officer's part. Right, so let's go and have a quick look at that one. Okay, so here we go. Same thing. All right, we're going to have the addresses there. Left-hand side is them. We are on the right. Same thing. Put the date in, the reference number. That's their reference number, the new debt collector one. Subject access request, follow-up and complaint notice. To Billy Borlocks in his private capacity, who sometimes acts as Billy Borlocks director. We are writing in response to our subject access request, SAR, dated, whatever date, regarding the alleged debt associated with account reference number, and then you put that in again. We would like to express our concern and disappointment that the requested information is specifically details of the deed of assignment under Section 1 of the Lower Property Miscellaneous Provisions Act 1989 and Section 136 of the Lower Property Act 1925 has not been provided to us. As you are aware, our SAR was submitted in accordance with our rights under the General Data Protection Regulations and Data Protection Act 2018. The information we requested is essential to verifying the validity of the debt and ensuring that all actions are compliant with Principles 6 and 7 of the Financial Conduct Authority's FCA regulations. We wish to remind you that your obligations under the data protection laws and your duty to respond promptly with and fully to SAR's failure to provide the requested information not only hinders my ability to assess the validity of the debt, but also raises concerns about compliance with data protection regulations. We kindly request that you promptly provide the following information, which was explicitly requested in our SAR. This is just a repeat. It's the three really specific questions. So we've got the one about the miscellaneous provisions. We've got the other one about the details of the compliance. And the third one, a copy of all personal data you hold on us in relation to the alleged debt. So you're just covering all aspects. You do not need any more than that. Now, all we've put at the bottom is failure to provide the requested information within a reasonable time frame. Now we're cutting it down to 7 days because we gave them 30, as is in the regulations. We have to. But now we can push it forward. We don't have to give them anything more than 7 days, and in accordance with the GDPR and DPA 2018, will compel us to escalate this matter. We will have no choice but to file a formal complaint with the Information Commission Officer, the Information Commissioner's Office, that's the ICO, to address the non-compliance with data protection laws. We strongly urge you to treat this follow-up request with the utmost urgency and provide the requested information without further delay. Your cooperation in resolving this matter promptly is appreciated. All rights reserved, without prejudice, by, and you're going to put your name there. You've repeated the questions. You've actually only repeated it the three. So you've been very, very specific. It's about the deed of assignment, legally executed deed of assignment, and also the validity of it. So they have to follow the regulations. They have to follow the GDPR and DPA 2018 by providing all data, especially when you've actually asked for it. Now, you're not asking them to bleed. You're not asking them to give you all your food and starve to death. You're asking them under your legal rights, because we're doing everything in the legal world. We're not trying to fluff around with it. We're not being silly. We're just following their legal requirements and their legal duties. So they must legally provide you with all the data they hold on you. Now, they have alleged that they have purchased your debt. Therefore, they must have a legally executed deed of assignment. All you're doing is asking them to provide it. We know they can't because they haven't done it. We've actually got paperwork proof that they never ever buy the debt. We've actually got it from the bank who supplied it to us. And we think, you know, just one of them things. And they show you, not only did they supply all of the templates that these DCAs actually use, which is hilarious when they accuse us of having templates, they have got templates provided by the bank to write this if you get asked for this, write this if you get asked for that. It's funny. This evidence that we have here from the bank shows that they never ever buy the debt properly. All they're doing is they're actually buying it, the data, and they even get refunded, right, for the data that they've actually bought if they can't enforce the debt on us. So there, the proof is fantastic. We're showing you this. Now, later on in the series, we're also going to show you with people that we've worked with how they've actually beaten these groups by using this evidence and using the actual courts. Why not when it's there for you? And this is the law that they call it. We know it's just statutory legislation, but we're using it against them. We're using it for our benefit. How great is that? So what we're going to do is, we've got the second one. We're going to send that off to the debt collection agency, and we're going to give them 7 days to reply. We have never ever had a reply within 7 days. Never. Not in the years and years and years that we've been sending these ones out. So what we're going to do is then we're going to go on to do the ICO notice. You must file a complaint with the ICO, the Information Commissioner's Office. I am not saying that the ICO are going to do anything for you, but you need that paper trail. So you've got that first SAR, you've sent it, you've got it dated, right? You've sent it first class post signed for, so you know it's been signed for, right, by that debt collection agency. You're going to send this second one, again, first class signed for, so you'll get proof that you print out as well from the Royal Mail, so that you've got now signature on the first one, signature on the second one. You keep all of this paperwork together because we are going to file against them for compensation. So once you've sent that SAR number 2 off, they haven't replied within the 7 days with full compliance. I mean, if they send a letter saying we don't need to give you anything, you don't ignore it. You actually keep all of the replies, because this is what you're also going to present as evidence to the court. This is your case. This is brilliant. They're saying they don't need to give you it, which is against GDPR. They're actually shooting themselves in the foot every time they actually write you a notice, write you a silly letter. So now we're going to file it with the ICO. I'm just going to quickly show you, and I'll put the links in the description on where to find the complaint section of the ICO. Okay, so sharing my screen again. Literally go to Google, you put in ICO complaints. It's going to be here. Look, there's the Information Commissioner's Office, ICO, make a complaint. There's the link. So you literally just click that link and you're going to get taken to their complaint section on their website. So we'll just click this. And here we go, make a complaint. So all we're going to do, what we're going to look for, nuisance calls, not really. FOI, well, we're not doing information. Cookies, well, don't want that. Data protection complaints, domestic CCTV, UK extension. Well, it looks like it's going to be about data protection. So we're going to click on that link. So data protection and personal information. Complaints tool. So down here we're going to read it, all right, but then it just says start now. So we're going to press the start now and go through it. So what is your complaint about? Access and personal information, how an organization is using personal information. An organization has sent me someone else's information by mistake. Internet search results. How an organization is using personal information. Let's click that and go on to next. Number 2, is your concern about how an organization has used yours or another living person's data? Yes, my data. Well, it is, isn't it? So we'll click that and go on to next. Is your complaint only about the customer service you've received from an organization? No. Click next. What is your complaint about? How an organization is using personal information. Is your concern about how an organization has used yours or another person's data? Yes. Have you complained to the organization directly? Well, we have, because we've sent 2 SARs. So we're going to put yes and click next. Next one, what was the outcome of your complaint? I have not received a response from the organization. I've received a response and don't understand it. I've received a response, I'm unhappy and I want to complain to the ICO. Well, I mean, obviously, if they haven't responded, we'll click that one. But if they have responded and it's not compliant, which they all are, never, ever, ever they compliant. So we're going to click that. I've received a response. I'm unhappy and I want to complain. Click next. So now it just says there, make a complaint. So we're going to make the complaint. Click there. So about your complaint, what is your complaint about? Access and personal data, how an organization is there. So we're going to click on it. What are the details of your complaint or the organization. Won't delete or remove? No. Won't correct information? No. Keep contacting me? No. Keep making automated decisions? Maybe, but no. Has lost personal information? No. Has used my information without my consent? Maybe. Has used my personal information in a way I didn't expect? Won't let me move my data to another service, or something else. Well, we're going to put something else. Give a short summary. Well, you know what you're going to put in there. You're going to put breached GDPR and DPA 2018 by concealing my data, as in not supplying me all data the organization hold on me when legally requested using the SAR. Tell you what I'll do, I'll put using the subject access request SAR. There we go. Supporting documents. Now I can't upload here, but literally you're going to upload. Let's see how many you can do. 1, 2, 3, 4, 5. Now we're only on our second SAR, so we're going to upload that one. Then we're going to upload the second one, the first and the second one. Then if they did, let's just presume that they've replied with non-compliance. So we upload their reply, take a scan of it, and we upload the second reply. Generally, they won't have had it, but if they have, you know, and then what I would also do is I would actually upload another file showing them that it has the Royal Mail signed for proof. So they actually know that they've received ours and signed for receiving it. So you just put the organization name, their address. You see, you fill all this in. This is pretty straightforward. And then you put it in all about yourself as well. I or the person complaint was as 17. You don't click any of that. Just fill all this in, fill it in completely, and then you press submit. And that will send your complaint off to the ICO. Now, you don't need to be waiting for a response from the ICO. We've had responses from them very quick, sometimes saying, yes, we agree, they've breached your data. They haven't been fully compliant, and we'll write to them and we'll tell them. And then we've actually had a reply. Same thing, though. They're trying to get away from showing you all the evidence, which is they haven't got a legally executed deed of assignment, so they don't want to show you the one that they haven't got. We've actually got deeds of assignment sent when we got to court phase, when they were trying to actually sue some of the people we were working with. Now, they send this deed of assignment, and it's blank. We've actually got it. It's from Barclays Bank, right? I've got the whole pack there. It's got the Barclays Bank director or managing director or whatever it was, completely unsigned for. The dates were years before this actual complaint, or years before this debt was actually there and created. There's no signature from anybody. There's no amount. There isn't even the details of the person, that they were actually saying they were going to sue for the debt. Completely blank, utterly false pile of nonsense. And it was about 30 odd pages odd thick. It's just a bluff to scare you to say, yes, we have a deed of assignment. You cannot use one deed of assignment from years and years ago to be everybody else's deed. It has to be legally executed per debt. That's why they can't do it. They just buy huge big blocks of data, right? That's how we actually do it. That's how we can hold them to account. So now we've actually filed the complaint to the ICO, right? We've told them that we were going to file a complaint after 7 days. As soon as you've filed a complaint, which will be 7 days after you've sent your second SAR, we're going to actually send the third SAR. Well, it's not an SAR. We're actually going to send them either a letter before claim or a letter before action. It's the same thing, but it's two different things that people call it. A letter before claim or a letter before action. That's going to be the next video, because I don't want this one to be too long. I just wanted to go through that process there. Sending the second SAR and telling them that we're going to make a complaint to the ICO, and then filing that to the ICO. Remember, we are creating a paper trail and we are creating our evidence pack, because we're also going to file for compensation using the N1 to the court. We're going to hold them to account. We're actually going to get compensation for the distress that they've caused us and the inconvenience of having to deal with the situation when they've alleged a debt that they cannot prove that they own. Go through that again. Have a look at the attached SAR. I'm actually putting the first one attached onto here. The second one, which is the ICO complaint notice that we're doing, and also the link to the ICO complaint website where you can actually file it with the ICO. This is your evidence pack we are putting in towards them. This is the only way to fight them. Use all of their legal tools. Use the GDPR. It's fantastic. It's powerful. Under GDPR and DPA 2018, they must give us full disclosure. They must provide you with all data held. They've got no excuse. And they cannot say, well, under the Law of Property Act 1989 or under the Law of Property Act 1925, it doesn't say we have to give you the deed. It doesn't. It's correct, 100%. So the argument coming from other people saying, well, they don't have to do that. Under GDPR and DPA 2018, they must supply you with all data. They've told us that they've got a deed of assignment. They've told us that they've actually purchased the debt. So they must have the deed of assignment. They've said so. So if they're not going to supply it, then we're going to actually sue them for breach of our GDPR and DPA 2018, right? They have our data. They haven't shown us it. They must show us all data held. They must. That's what we're doing. Follow that structure, go down that route, so we can actually get a claim for compensation, which will also get rid of the debt, because they're not going to be following you up with more letters asking you to repay the debt. With every time that they actually do it, you're going to get another 5,000 in compensation because they've actually breached your data and they haven't got a deed of assignment. Now, one thing here I just want to make a note of. If only, I've had this from somebody sent me an email and it says, but this, what they're doing, sometimes this one group, they're actually selling the debt, right, what they say, to another part of their organization. All right, so what they're doing is they're selling it and doing a deed of assignment. If they haven't got the initial deed of assignment from the original creditor and they're actually selling a deed of assignment on, that to me sounds a little bit like fraud. So I wouldn't be worrying if they've actually resold it to another part of their group and calling it a different part of their organization and there's a deed of assignment, because they're going to get into some serious trouble for that, because that's fraud. Forget about the GDPR and the DPA 2018. If they're committing fraud, then we can actually hammer them with that as well, right? So don't worry about that. If that does happen, I've never actually seen it myself, okay? But you have nothing to worry about. We need the original deed of assignment, the illegally executed deed of assignment from the original creditor. We're fighting them with GDPR and DPA 2018. Forget if you owe the debt or don't owe the debt. If forget about all the law, the proof of the debt, or any of that evidence there. We are actually going after them with the breach of data, what they have actually done. Have a look through the stuff. Hope you enjoy it. And then watch out for the next series, which I'm going to go through on how to actually do the letter before claim or letter before action, whatever you want to call it. Doesn't really matter. But it's following the rules set out by the court procedure rules. That's why we need this evidence. So watch. This is the rule book we're following. Okay, so on the rule book we're following, what we actually do is we're looking at on here, and then it goes on to CPR 31.6, which also shows you that they have to disclose all of the information that you request. So if you are even defending, which we'll go over in different videos, then we actually file this with the court. So we're going to use CPR 31.6, which shows them that they have to supply us with all of the information that they have and what they rely on for their case. So we're just following the rules. Now, the rules actually state as well that you have to give them a letter before claim or a letter before action to say you're going to take legal action. All right, so that's why we're doing it. That's why we're actually creating this paper trail of evidence, because we're going to use the claim against them. How good is that? We're actually going to turn the screws on them, which are like, you know, they're just the parasites of these debt collectors. Now we're turning the tables on them and we're actually going to hammer them. See you next time.